There's this concept called release of lien, and typically that is used when the sub has been paid in full for their work. They will then sign a document that says, okay, I've been paid in full. I'm agreeing that I won't file a mechanics lien on this property.
Okay.
That's the reasonable and normal way to use it. However, that gets abused. People say, sign this contract and sign this release of lien before you've performed any work on this thing, or before you've been paid a penny. And so subcontractors a lot of times don't know these things, and they're usually, again, smaller mom and pop, small business.
Sure.
And if they push back on this, a lot of times general contractor will say, okay, fine. Sometimes general contractor will say, okay, I'm going to deal with somebody else then that's going to sign my agreement. But there's risks to that too. I mean, and we'll talk about the insurance and liability risks, I think, a little bit down the line.
And the courts don't inherently protect you. I mean, if in the same way that we've talked in the past about non-competes and things like that, the courts don't have a provision where if you sign this release before you even started the work, where the courts go, hey, this was unreasonable. Well, it just you signed it, and that's it.
I think that there's a misconception about how courts work for people. I think that, and I think you're a perfect example of it right now. By the time that we have a court or a judge review whether or not that piece of paper is valid, each of us will have spent tens of thousands of dollars.
Right.
And so I think a lot of the way that lawyers and court systems work is it's really, an exercise of holding bigger and bigger guns to each other's heads. And so if you have...
It's a great visual. I hope we can find a
right.
way to
It's like
that.
what is it? The Marvin the Martian with his big gun.
Right.
Anyway, so if you have this release of lien that you signed for no consideration whatsoever...
Mm-hmm.
Maybe that is an invalid document, right? But by the time that you actually have a judge decide that, you will have spent so much money. And so it doesn't matter whether it's a valid or a non-valid document. I mean, it matters for legal purposes and for taking the thing all the way down the line, but for practical purposes, it doesn't matter.
Right. And if you did a $20,000, $30,000, even $50,000 window job as the subcontractor, and now you're waiting 6 months to a year and dealing with the courts and all that stuff and spending tens of thousands of dollars on top, is that really money well spent?
Right. And that's why to answer your question, that's why this mechanics lien statute exists. And because it is that protection. Right. Mm-hmm. So now I'm the subcontractor. I'm getting the short end of all of the sticks. I'm filing a lien. So the only thing that can prevent me, and I don't want to say the only thing, one of the main things that can prevent me is signing this release of liens. So, if you're a subcontractor listening to this, don't just sign documents. Okay. Make sure you're getting paid before you sign documents, or make sure that you read your agreement or have a lawyer read your agreement before you sign documents.
In the contracting world, what do we say? Measure twice, cut once, right? So this would be the equivalent of that, I guess.
Yeah. We're the second measure.
You're the second measure. I love it.